So not only Nationwide, we also know, I mean, it's obviously Comair as well, which is, of course, putting a spotlight on SAA. And one of the reasons that this has actually come to the fore quite extensively is because SAA has been paying a penalty of around 18.8 million rand with regards to flights that were made to Hong Kong. Is this now creating a far better environment for the civil judgments and the claims that could actually come through for SAA?
Correct, Eleni. There are currently 2 claims by Comair, in addition to the recent Nationwide one, which are currently pending before the High Court. But in addition, in relation to this latest 18.8 million rand penalty, which the Competition Tribunal has confirmed against SAA, there's a prospect or a likelihood that further civil damages claims may eventuate against SAA in relation to these most recent decisions.
Well, interesting, a lot of these decisions, and if you look at the issues that actually came to the fore, we're talking about anti-competitive practices from 1999 to 2002, and then from 2003 to 2005. So we're looking at actually two claims that are coming to the fore.
Well, the first set of claims relates to SAA's abusive dominance conduct, which occurred between 1999 and 2005. That related to SAA's conduct of offering travel agents incentive schemes, which the tribunal found to be anti-competitive. The latest fine imposed by the tribunal relates to price-fixing conduct by SAA in relation to flights between Johannesburg and Hong Kong.
Let's also just touch on Comair's role here, because at the end of the day, we're also looking at civil claims, civil judgment claims coming to the fore from Comair to SAA. We know that both are actually pending, the 2 scenarios that I was talking of. We know that Nationwide is also now embroiled in this quite extensively. Could you shed some light with regards to that?
Well, those claims have been before the High Court for a number of years now. They are, in fact, quite interesting in the sense that they are the first real claims, civil damages claims, that have come before the South African courts pursuant to anti-competitive conduct. This is an area which is quite developed in places like the States and Europe, although in South Africa it's very much an area of law that's in its infancy. And so what we anticipate is that since these are really test cases in South Africa, following the outcomes, if they do go against SAA, there may well be a flurry of further civil damages claims in all competition proceedings.
So you're saying, I mean, South Africa is relatively behind when it comes to civil damages claims that we've been seeing relative to the EU and the US, because in the US we know that we could see claims up to 3 times the actual losses to make up for the anti-competitive.
Correct. I mean, obviously South Africa is a very young nation when it comes to competition law. Our act has only been around for 10 or 12 years, whereas in places like the States and Europe, competition law has been around for 50 or 100 years even. So obviously our law is developing, and it's following on from those developments in Europe and the States that these civil damages claims are coming to the fore now in our law.
18.8 million rand that is going to be paid, or I think it already has been paid by South African Airways. But what about the actual consumers that were affected? How do they get a piece of the pie? Because we know the overall money actually just goes into the government fiscus.
Well, that's the interesting legal question, is how would consumers go after SAA for fixing the prices of tickets between Johannesburg and Hong Kong? It's a difficult question to answer because it's something that we really don't know what the answer is. Traditionally, these types of claims by a disparate group of consumers would be brought by way of a class action. For instance, there was an attempt last year by a group to bring a class action against the bread manufacturers, which was was dismissed by the Cape High Court. So it's unclear in our law how our courts would recognize class actions in relation to civil damages claims for anti-competitive conduct.
What is the trend that is playing out in Europe and the US, and would we be willing to adopt similar mechanisms?
Well, certainly in places like the States, where there is historically a strong civil and class action litigation regime, there are class action litigation that's recognized there and that's well developed there. In Europe, in certain jurisdictions in Europe, they do recognize civil actions and by way of class actions, but in others, they are still developing. And we foresee that in South Africa, the trend will lag that of Europe. So as things develop more in Europe, so it sets the precedent for our law to develop in South Africa.